Hi all ladies and gentlemen. Today we will talk about XRP, a cryptocurrency that has been bugging no one until now. What will happen next? I have prepared for you some documents with information which for sure will be useful for you. Because thanks to it, you can understand in what direction to move. And before we begin, I want to ask you to subscribe to my channel because it will be useful to you in the future quality news information that will not let you fall below the level that is now. Well, now let's go. Is now. Well, Ripple CEO is optimistic the crypto firm will get ruling on XRP lawsuit soon, slams embarrassing SEC. Indeed, the SEC case has already dragged on for as long as one can imagine. The denouement, however, will not come soon enough. Brad Garlinghouse, CEO of crypto company Ripple, said he is optimistic that a ruling on its legal dispute with the Securities and Exchange Commission will be reached in 2023, potentially in the first half of this year. The lawsuit relates to whether XRP should be treated as a security has important implications for both Ripple and the broader crypto market. Garlinghouse sternly rebuked the SEC's legal battle with his firm Wednesday, saying the conduct of the agency so far had been embarrassing. The head of cryptocurrency and blockchain company Ripple, Brad Garlinghouse, says he is hopeful a resolution will be reached in its spat with the U.S. Securities and Exchange Commission within the first half of 2023. Judges take however long the judges will take, Garlinghouse, who is a defendant in the legal drama, said in an interview with CNBC's Squawk Box Europe Wednesday at the World Economic Forum in Davos, Switzerland. We are optimistic that this will certainly be resolved in 2023 and maybe in the first half. So we'll see how it plays out from here. But I feel very good about where we are relative to the law and the facts. The U.S. Securities and Exchange Commission initiated a lawsuit against Ripple in 2020, alleging that the company and its executives illegally sold XRP, a cryptocurrency created in 2012, to investors without first registering it as a security. Ripple disputes the claim, saying that the token should not be considered an investment contract and is used in its business to facilitate cross-border transactions between banks and other financial institutions. In December, Ripple and the SEC submitted their final round of briefs seeking a summary judgment to the case, respectively accusing each other of stretching the law. The judge could make a ruling in favor of either side, avoiding a trial, or put the matter before a jury. Garlinghouse said that he expects a ruling to arrive sometime in the coming single-digit months, potentially as soon as June. He added that he doesn't expect the company will settle the case, although he remains open to the prospect. We have always said that we would love to settle, but it requires one very important thing, and that is that, on a go-forward basis, it's clear that XRP is not a security, Garlinghouse said. The SEC and Gary Gensler has very outwardly said he views almost all crypto as a security. And so that leaves very little space in the Venn diagram for settlement. At a September event organized by the Practicing Law Institute, Gensler said that the vast majority of cryptocurrency tokens are securities. He subsequently hinted that Ether may also qualify as a security. Without referring to it by name, Gensler told reporters in September that crypto staking mechanisms, which reward users who deposit their tokens to secure blockchain networks with interest-like payments, should count as securities offerings, since the investing public is anticipating profits based on the efforts of others. Ethereum, the network behind the world's second-largest cryptocurrency, switched to such a model last year. The only cryptocurrency that the agency has made clear it doesn't view as a security is Bitcoin. Gensler previously stated that the world's biggest cryptocurrency has no group of individuals in the middle, meaning investors aren't betting on an intermediary. The XRP case has important implications for both Ripple and the broader crypto market. A judgment pronouncing XRP a security could potentially impose much stricter curbs on Ripple with respect to the token. This could include requirements for transparency disclosures and greater investor protections, akin to those imposed on regulated broker-dealers. It may also set a precedent for dozens of other crypto and blockchain projects that could potentially be classified as securities. Stressing the significance of the lawsuit's outcome, Garlinghouse said on Wednesday, "Something I've heard here in Davos repeatedly is how important this is not just to Ripple, but also, really, the whole crypto industry in the United States." He added, "I keep reminding people that outside the United States, crypto is still thriving, Ripple's still thriving, and we should make sure we're continuing to engage non-US regulators as well." Embarrassing behavior. In a separate fireside discussion with CNBC's Arjun Karpal Wednesday, Garlinghouse issued a stern rebuke of the SEC's legal battle with his firm, saying the conduct of the watchdog so far had been embarrassing. "From the beginning, I thought it was very clear that the facts were on our side, that the law was on our side," he said. "And I think as you have seen this play out, as you have seen the filings in the court, that the judge certainly is hearing our arguments." He went on, "The SEC's behavior and some of it has been embarrassing as a US citizen. Just some of the things that have been happening, like you've got to be kidding." He said the US is notably absent from the list of regulators developing crypto-friendly rules. The United Arab Emirates, Japan, Singapore, Switzerland and UK are some of the forerunners in this respect, in his view. As part of the legal proceedings, Ripple filed to obtain documents related to a June 2018 speech from former SEC official Bill Hinman, which it says have aided the case. In the speech, Hinman says that sales of rival Ether are not securities transactions. XRP was once the third largest cryptocurrency, commanding a $120 billion market value in early 2018. It has dropped sharply since, amid US regulatory scrutiny and a wider downturn in Bitcoin and other digital currencies. XRP now has a market capitalization of roughly $20 billion, according to CoinMarketCap data. It was interesting enough information, but that's not all we need. What do you think? Write in the comments. Such big money. Look what we have here. It's time to get to grips with this, deciliters. SEC charges Ripple and two executives with conducting $1.3 billion unregistered securities offering. Washington, D.C., December 22, 2020. The Securities and Exchange Commission announced today that it has filed an action against Ripple Labs Incorporated and two of its executives, who are also significant security holders, alleging that they raised over $1.3 billion through an unregistered, ongoing digital asset securities offering. According to the SEC's complaint, Ripple, Christian Larson, the company's co-founder, executive chairman of its board, and former CEO, and Bradley Garlinghouse, the company's current CEO, raised capital to finance the company's business. The complaint alleges that Ripple raised funds, beginning in 2013, through the sale of digital assets known as XRP in an unregistered securities offering to investors in the US and worldwide. Ripple also allegedly distributed billions of XRP in exchange for non-cash consideration, such as labor and market-making services. According to the complaint, in addition to structuring and promoting the XRP sales used to finance the company's business, Larson and Garlinghouse also effected personal unregistered sales of XRP totaling approximately $600 million. The complaint alleges that the defendants failed to register their offers and sales of XRP or satisfy any exemption from registration, in violation of the registration provisions of the federal securities laws. Issuers seeking the benefits of a public offering, including access to retail investors, broad distribution and a secondary trading market, must comply with the federal securities laws that require registration of offerings unless an exemption from registration applies, said Stephanie Avakian, director of the SEC's Enforcement Division. We allege that Ripple, Larson, and Garlinghouse failed to register their ongoing offer and sale of billions of XRP to retail investors, which deprived potential purchasers of adequate disclosures about XRP and Ripple's business and other important long-standing protections that are fundamental to our robust public market system. The registration requirements are designed to ensure that potential investors, including, importantly, retail investors, receive important information about an issuer's business operations and financial condition, said Mark P. Berger, deputy director of the SEC's Enforcement Division. Here, we allege that Ripple and its executives failed over a period of years to satisfy these core investor protection provisions, and as a result investors lacked information to which they were entitled. The SEC's complaint, filed today in Federal District Court in Manhattan, charges defendants with violating the registration provisions of the Securities Act of 1933 and seeks injunctive relief, disgorgement with prejudgment interest, and civil penalties. The SEC's investigation was conducted by Daphne A. Waxman, John A. Daniels, and John O. Enright of the SEC Cyber Unit. The case is being supervised by Christina Littman, chief of the SEC Enforcement Division's Cyber Unit. The SEC's litigation will be conducted by Jorge G. Tenrero, Dugan Bliss, Ms. Waxman, and Mr. Daniels, and supervised by Priyathi Krishnamurthy.